Mr. Montoya, you've requested in writing a motion for continuance. Tell the court what your request is.
I requested, due to my financial hardship, and a legal assistant through Texas Legal Aid.
Have you attempted to contact legal aid?
Yes, I have.
And have they expressed to you whether they will be taking on your case or not?
Unsuccessfully on the short range that I had to come here. I waited hours before I can get the hold of somebody. But a counselor from the legal aid office has helped me to come this far. But he advised me get a lawyer, Mr. Montoya. For now, I'm going to help you with this, but you got to get a lawyer. And then for the future date, because you got to show your discovery to a formal court. And he read everything. So that was the best advice that I would take.
Who is that person? I don't understand.
Mr. Reina.
Mr. Reina, legal aid says you need to hire a lawyer.
Yeah, because he hasn't had an office yet established, but he say, we're working on that. But personally, I need to get a down payment. They're asking me $10,000. I don't have that kind of money, Your Honor. I can barely make it for the rent. For the
I think you're telling the court that Israel Reina, the director of the legal aid, is going to open up a private practice and is charging you $10,000 to make an appearance in this case?
He doesn't. No, I don't have. I can mention names. Per se, Mr. Bella Jr., Nathan Chu.
Oh, he's guiding you to hire other lawyers.
Yeah, because he doesn't have an office
Because
until September. He get officially, but
I understand.
Before you get.
So he's recommending that you consult with lawyers.
Yes, sir.
Understand. That
Yes.
makes perfect sense now. Ms. Vidauri, Mr. Montoya is requesting some time to look for a lawyer, to talk to a lawyer, and to possibly listen to my question. My question is, do you have an objection to the court giving Mr. Montoya time? Yes, please do.
Because I'm hard of hearing, I don't hear what he's saying. This man was going to buy my house, and this was in April 12, 2021. He was supposed to have bought the house for $180,000. He was to give $30,000 down. He was supposed to pay the taxes and insure the house, but he refused to pay the taxes, and I paid him so I wouldn't lose my house. And then he refused to insure the house, and he breached the contract. And so he never did give it a down payment or do anything. But 4 months later, his attorney, Trevino, his first attorney, told him he was going to lose a lot of money, and to take possession of my house. And he and his lawyer broke my locks. And the first time I was able to hire somebody and, go ahead and get possession of my house. But the second time, I didn't realize he had taken the big chain from my tollmaster trailer, and he wound it around the entrance where I could go into the utility apartment and get in. So he took possession of it July 1st of 2023. And he's been living there without giving me a penny. And he has been renting the house also. And it's been very, very hard for me. I'm 91 years old, and I really don't need for him to be doing these things to me. I did hire my attorney, wrote this letter Jimmy Sandoval was my attorney. He was my cousin also. And he wrote this agreement. I would like to show it to you. The agreement to buy the house and what we were supposed to do. May I give it to you?
Yes. The court takes judicial notice that this is a public document filed with the clerk's office. It is document 1500987. Before I read the details of the letter, Ms. Vidauri, the question that the court has is, what is the specific objection to giving Mr. Montoya more
Because
time?
living free in my house, they cut my locks. His attorney, his first attorney, told him he was gonna lose a lot of money and to take possession of my house. And they broke my locks and he's been living there rent-free without giving me anything. And he's destroyed my house. He's been using the only thing he brought when he moved in were his clothes and some tools. And this was after he gave 10,000. And I said, no, you have to pay 30,000, pay the taxes and go ahead and insure the house. And then he decided he wasn't going to buy the house at all.
All
He
right,
said
so
he
so
would
what
pay
I'm
the
hearing
taxes.
is that your objection is that it'll create additional hardships for you.
Because he's been living there free.
I understand.
This
I
is
understand. I understand. Give me 1 second, Ms. Vidauri. Mr. Montoya, have to first make a decision on your request for additional time. And give me 1 second while I make a decision as to whether to give him more time or not give him more time. So, Mr. Montoya, your motion for continuance says that you need time to hire a lawyer. Is that right?
Yes, sir. Yes, Your Honor.
So two things with that. First, there has to be good cause shown in your request for continuance. I see that this case was filed with this court May 4th, 2026. So you've had at least 2 months to hire a lawyer, but you knew about the case going back to a justice of the peace court. The next thing that I find is that you filed, let me make sure that that was you that filed this. You filed a statement of inability to afford payment of court costs. So the question I have is, if it's true, and you verified it under oath, you made this declaration under oath, and I say this with all respect, if you cannot afford court costs, what is going to change between now and sometime in the future to afford a lawyer?
I received my first retirement check, which is going to be approximately $1,400. That will cover her rent. I am a New York City taxi driver for the last 10 years, 11 years, which I say accumulated her first $10,000 and the additional $20,000. I sold a property in my country to subsidize not only her 20,000 extra that I gave her, 20,500, total of 30,500, which is on the record.
When did you come into all this money?
My savings for the last 5 to 6 years doing a taxi service and doing maintenance and construction locally in the city of Laredo. I moved in here 14 years ago to legalize my wife. That's the reason I needed to buy a house. Under Homeland Security regulations, I need to have stability and financial home for my wife and my 3 children that are across the river. And due to the violence, I cannot see my family. and she's taking my savings from me and my house. She wants to, but I'm not gonna allow it to happen.
I feel for each and both of you, but the question still remains. If you can't afford court costs.
No, I can afford the court costs, but it needs to be up to this point. If you allow me to continue my case, I believed I already saved myself at least $5,000.
How?
Because all of these documents, all of these pro bono that I'm getting help for has helped me to come this far. Otherwise, I would have been homeless and without $30,500 plus $20,000, $20,000 that I was granted for a breach of the contract, which
When did that happen?
that happened on March 12, 2026. I was granted $20,000 for damages on my favor, and she would take nothing against.
But you didn't list that in your affidavit to afford court costs.
Excuse me?
You didn't list that
Oh,
in your affidavit to afford court costs.
it is-
You
it-
said,
it's-
listen to
it's
me,
a different-
listen to me. Under oath, you put a very detailed statement about all of your income and your debts and obligations,
And I did.
and you didn't list that $20,000 or $30,000.
It's mentioned on the original petition that I gave Mr. Oscar Liendo on the first floor. Oscar Liendo, the same day, I said, if you don't agree with me, appeal it, but you're gonna have to write in a statement. So.
And when you appealed it, you filed a statement of inability to afford payment of court costs after your time with Judge Liendo, because that was before the date of this, which was May 7th.
It was on May 7, and on April 29, I submitted the letter to Ulises, Mr. Oscar Liendo.
My point is this, that this document I now believe to be not true because you failed to disclose something. And if you're telling the court under oath that you can't afford court costs in one document, but now you're telling the court I need more time to hire a lawyer, even though I can't afford this case, that doesn't make any sense. So based on all of that, I find that there is no good cause because of that, and because you've had the 2 months. You've had this money since April, if that's what you're saying, to go out and hire a lawyer. You have just chosen not to, but you're here now. So let's go forward. The motion for continuance is respectfully denied. So this now becomes your case in chief, Ms. Vidauti. Ms. Vidauti, tell the court what, have I placed both under oath?
No,
Ms.
No,
Vidauti, Mr. Montoya, I'm going to ask that you both raise your right hands.
yes,
Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
yes, only God.
Both have answered yes. Ms. Vidauti, you are the person that is requesting something for the court. You are the person that is making a request to the court. So this is your case. What would you like to tell the court? You're under oath.
Tell the court that this man, he is not truthful. He claimed that he had paid me all this money. He never paid me any of this money. He puts my account number and he puts figures down. And then the only thing that he paid to the through Tex-Mex Credit Union was $14,000. He never gave that $30,000 down. And you know, this then 4 months later, he told me he didn't want to buy the house. He was gonna not pay the taxes. He was not going to insure the house. But 4 months later, they broke my, he and his first attorney, Trevino, broke my locks, and he's been there 3 years without paying me anything. And he's also renting the house, I know. And this is not good, Your Honor, because the only thing that he paid was $25,500 to buy that, and he was supposed to pay $30,000. And he never paid $30,000. And this is not good to be living in my house and kicking me out. That's my house. I was using it. And I'm an old lady and I'm 91. I don't need this aggravation. If he wants more time to live there free, that's not good, Your Honor.
Let me ask you this, Ms. Vidauti, you've handed the court an agreement.
He broke it. He breached the
I-
contract.
Let me ask a question. What did this agreement do?
And says that he was supposed to, okay, buy the house for $180,000. He was supposed to give $30,000 down. He was supposed to pay the taxes, which he did not do because they were too high, 4,400 plus for 21 and more for 2022. I had to pay him, so I would lose my house. So he hasn't even paid that. He never would insure.
Well, let me ask it this way. This agreement talks about a warranty deed with a vendor's lien.
What-
Did was a warranty deed signed?
No.
Who then is the owner of the property?
Already went to the appraisal district. And he told him he showed the agreement and told him he bought my house and put in and well, that's all we know. And this is a letter that he wrote to the second attorney that he had, Shu. Would you give it to him?
So I have reviewed the lawsuit in cause number 2023 CVI 001397D3. As you both recall, both of you sued each other years ago in district court in the 341st Judicial District Court. The case was presented to a jury, and this is what the jury found. I'm going to read you their verdict. Question number 1. Did Raquel Vidauti and Alfonso Montoya agree in writing that Alfonso Montoya would pay $30,000 as a down payment to purchase a property more commonly known as 1020 Garfield, Laredo, Texas? Answer yes or no. The jurors said yes. That matter has been established as it's as a matter of law. That's exactly what the jury found. Question number 2. Did defendant Alfonso Montoya breach the contract with Raquel Vidauti? Answer yes or no. The jury found yes. There was a contract for $30,000 and there was a breach. Question number 3. What sum amount, if any, paid now in cash would fairly and reasonably compensate Raquel Vidauti for her damages, if any, that were caused by Alfonso Montoya's breach of contract? They answered $0. Question number 4. Did plaintiff Raquel Vidauti breach the contract with Alfonso Montoya? Answer yes or no. The jury said yes. Question number 5. What sum of money, if any, if paid now in cash, would fairly and reasonably compensate Alfonso Montoya for his damages, if any, that were caused by Raquel Vidauti's breach of contract? Answer separately in dollars and cents for damages, if any. The jury answered $20,000. Question number 6. Instructions. Factors to be considered in determining reasonable and necessary attorney's fees. They were given some factors and they answered the answer to the question, what is a reasonable fee for the necessary services of plaintiff's attorneys? Answer in dollars and cents. The answer was $0. All of those things have been established as a matter of law. I don't need to relitigate those things here because the jury answered what the law and the facts were. So I guess the question the court has is, on that jury verdict, have you paid Mr. Montoya $20,000?
No, because they lied. And his first attorney, Trevino, told the court that I had had an illicit affair with him. And this is defamation of character. that never happened. And this is the worst thing that he can do to me because that's awful. And another thing, his second attorney, Nathan Chu, my attorney was Jimmy Sandoval. He was my first cousin and my attorney for 30 years. And this letter was written to Mr. Chu. And he also asked to the jury the condition of my house. He told them that it had holes and that the apartment had a vanity that she had to replace. This vanity was the most beautiful sink in my husband bought it to me when we remodeled the house, and he bought it for $1,500. And he said he had to remove it because he stole it. And this is not good for defamation of character.
But we're not here for any of that. None of that matters. We're only here about possession of the home. So what I need to hear and what I need to understand is who owns the home. And listen before you answer. These are my questions. What I need to know and what I need to understand as the judge of this court is, one, who owns the home, and two, who has the superior right of possession. So as to the first question, Ms. Fidauri, who owns the home? Is there any warranty deed with a vendor's lien that ever conveyed the home to Mr. Montoya? Okay. Has Mr. Montoya performed pursuant to the terms of this contract?
He breached the contract.
Has he paid you any money?
No.
When was the last time when was the last time he paid you?
To give me a $30,000 down payment. He was supposed to pay the taxes, which were $4,400 plus for 21. And
Where does it say that in the agreement?
and I'd like for you to read this, please.
Let me see it.
That's from my attorney. He died the same day, my attorney, Jimmy Sandoval. And,
But this isn't this document is not signed, and it's not a legal document. This document has no legal authority whatsoever. This other one that you handed the court is signed and it's filed with the county. So under this contract that is signed, it says, and you signed it, and Mr. Montoya signed it as the buyer. So this is the legal document that has full effect in this case. So we're not talking about property taxes. We're only talking about the payment of $180,000. Has Mr. Montoya paid you that amount?
how much?
180,000 total.
No, he never paid me 180,000.
Did he give you a down did he give you a down payment of $30,000?
No, he didn't. He paid 25,500.
How much?
25,500.
Did he pay you any weekly amounts?
No, well, he has paid the court, but I haven't received it because we're here.
Let me hear from you, Mr. Montoya. I have reviewed the agreement that's filed with the county, and I have also reviewed the lawsuit where Ms. Vidauri sued you and you sued her back, and then you won at least $20,000 in that case. What does the court need to know?
The court need to know that I never sue her. Never.
Well, that's not true.
I'm only the defendant, always.
Give me 1 second.
I've been here about 300 times in the past 4 years. She was 86 years old.
Give me 1 second. Give me 1 second. You did. You sued her on September 21st, 2023. Your cause of action, which means the thing that you sued her on, was
I respond.
not until I'm done. Give me 1 second, please.
Sorry. This is Mr. Trevino. answer.
Counter defendant.
That's why I don't under, I don't, I, is that that's why I don't understand very well the counter and what is counter and when is, I apologize. I apologize.
I can't hear what you said.
In your counterclaim, you sued Ms. Vidauri for $30,500, and I think they awarded you 20,000. So you did sue her. So that that part that you told the court was not true. You did sue her, and you won that lawsuit for $20,000. Now that I've cleared, so that's two. That's now so think about the position that you put yourself in, because the first thing you told the court was that in writing in an affidavit that you couldn't afford the court costs, but you had all this money come into you
Well,
the month before you filed that document. You just told the court. And now you're telling the court that you never sued Miss Vidauri, but you not only sued her, you took it to a jury and you won. So let me ask you this question. Is there any dispute that Ms. Vidauri is the legal owner of the property?
that's, Your Honor, I'm asking for a lawyer. If the reason, Your Honor, I don't want to misrepresent myself, but I will answer the question to you if it
Go ahead.
doesn't affect my rights under Fair and Housing Administration. I think she is committing fraud against me, and it's a grand larceny. This is why I need discovery. I don't want.
But you had that chance.
Your Honor,
You had that chance in 2000. So we're not here to relitigate. Both of you, not just one, but both of you have already used a court, the 341st, to litigate all of this. So all of those claims you can't come to court over and over and over and over and over and make the same argument. You can't do that,
okay.
right? So the jury has already found that there was a contract, that Ms. Vidauri is the owner, unless you come up with some different information. Now, the fact that she's the owner, that doesn't absolve her of paying the $20,000 that the jury awarded you, but that doesn't mean that she doesn't get to take the property if she in fact owns it and you haven't paid. So the only question I need to know now is, if she is the owner, have you complied with the terms of the agreement that allow you to stay in the property?
Yes, I have.
Tell me how.
Yes.
Tell me how.
Oh, I'm sorry. Tex-Mex Credit Union, who's been financing me. I borrow money and I put collateral, my cards, my taxi. I'm not making the same money, but the town is kind of in bankrupt, especially downtown. So I'm juggling, doing maintenance and landscaping right now. This is a letter from the president of Tex-Mex Credit Union, Mr. Cesar Oldham, and he gave it to me to give it to Oscar Viendo of the 19,000 on money transfer from my account to her account. This is $19,000 if you would like to see it. It's a letter from Mr. Allman, $19,000 in money transfers. And this is 11,500 from Chase, certified checks. If you add 19 and 11,500 is 30,500. I delivered to her. This is what I need discovery, because I need for an official or in more detail, Mr. Allman give a letter to you formally, because he suggested me to hire a lawyer, Mr. Allman. This letter he gave it to me on April 28, 2026, only 3 months ago, when she did the eviction against me. So I went to Mr. Allman and said, please help me, because this is too many members. what you gave me here, when Mrs. Vidari said that I only gave her 25,500, there is $6,000 missing on my transfer to her. Why she's saying that I only give her 26? When you gave me a letter that you gave her 30,500, there is a discrepancy of $6,000 that I need for me to pay a lawyer or to help me. And I've been,
Let me ask you this, Mr. Montoya.
yes, Your Honor.
Under the terms of the agreement, what do you believe you had to do to purchase the property?
I had to get a vacancy in a mortgage lead and to deliver 30,500 to her, which I did.
Did you do all of that?
Yes, I did, Your Honor.
And when was the last payment you made on this?
Today,
And before today?
last month,
And what amount?
$1,500 in the last 3 months, which was
$1,500 in 3 months?
total 4,500. I gave it to your court downstairs.
Oh, because it's being held by the court.
It's right here. And I got copies of the check. I delivered one today. It's a Relatuque.
Let me ask the clerk's office, how much is in the registry of the court in this case? 2,500? 4,500.
And I did pay taxes. 2024, I paid them.
Do you have
Because-
proof?
Yes, I do. It's right here. I got copies.
Do you, Ms. Vidauri, are the taxes current on this property?
Yes, they are.
I'm asking Ms. Vidauri, you said that the taxes are current. Who has paid the taxes?
Is it taxes? He didn't pay for 21 or 22. He refused to pay them.
You are the owner.
I was the owner that you were buying.
Yeah, don't,
Sir, Your Honor,
Ms. Vidauri, when was the last time you received money for the purchase of this home?
because the court is, those 1,500 he's giving were under, the Honorable Oscar Liendo, and they're holding them because we're not sure with the case. I haven't received any money, but my question to you is, how can he sue me if I was never served and I never went to court and he won 30,000 something? I don't understand this. I didn't know he had sued me. I never received anything. I don't know. He said claim he paid this. He put my number on it.
Ms.
but I never received.
Ms. Vidauri, did you have a jury trial January of this year?
Yes, but he lied.
So when
They
you
said,
say, so when you say,
Information of cash.
for the judge to finish speaking about. So, Ms. Vidauri, when you say that Mr. Montoya has never sued you, never served you, that you never appeared in court, what the court notes show that in the 341st case, there was a jury trial, also January 12, 2026. Judge Palomo presided. Marcel Knotson, attorney, was present. Attorney Nathan Chu was present. And you and Mr. Montoya were present. So how can you say that you didn't know and you didn't go when you did know and you went with a lawyer?
Yes. But I didn't know he had sued me before for 30,000.
It's just hard to believe both. One, because of the affidavit, and you, Ms. Vidauri, that judgment was signed by Judge Palomo February 18th, 2026. So you must know that Mr. Montoya did sue you and that the jury awarded him $20,000 against you because you were there and you had a lawyer. So this is what I find. With regard to this case, you may, so that I can review them before making a decision. Let me review them. Let me review them.
He never did. The actual payments were 14,000 from Tex-Mex to my account. Were 14,000. The 19,000, I don't know what he did with the money. He put that, he paid it to me, but those never went into my account.
All right, I have reviewed those. Anything else that anybody else wants to say?
To say that I went to court all the time that I was supposed to go and they never called me, never. My attorney didn't go, my first attorney died and nobody ever went. And I am hard of hearing. They never called me because I checked with the clerk and they never did call me. So I don't know what he sued me for. He's been living in my house for 3 years without paying anything.
All right, anything else you want to tell the court, Mr.
I'd like for you to read this. Please.
Let me see it. Well, this is exactly what I've been referencing. The court takes notice, court takes notice. This is in cause number 2023 CVI 001397D3. There is a judgment where you lost against Mr. Montoya. The jury found in favor of him in the amount of $20,000 and you were not awarded attorney's fees. That's exactly what I've been talking about.
It's what I put in number 2. They believe what he said about me.
Well, but that's what a jury does. They believe one side or they believe somebody else. That has nothing to do with me. But I can't undo a jury verdict. Is there anything else that you would like to tell the court, Ms. Fidauti?
Yes. Mr. Knoxon, that we were in the wrong court because he never debriefed the contract.
All right, let's do one thing. Okay, I'm not going to do this because I'm not going to do the work of another court because I can't undo what happened in another court. I can't undo another jury trial, another jury verdict. I must, as a matter of law, uphold any and all other orders that happen in other courts. I can't change that. Even if everything you're saying is true, I can't change that. Is there anything else that you would like to say, Ms. Fidauti?
I would like to take possession of my house because it's not right for him to be living there. He broke my locks and he technically stole my house and I don't have anything in there anymore. He's been there 3 years without paying anything. He's renting the house and he's done a lot of damage to my property.
All right, is there anything else you would like to say, Mr. Montoya?
Your Honor, can I ask you respectfully to review these checks, please?
Sure, give me the checks.
This is $10,000 certified check.
Those were from when he breached the contract.
Okay, I reviewed those.
Paid the 30,000.
Certified check and a cash receipt. I just don't want to give you everything. That's 1,500, 2,500 and one cash with a receipt cash is signed.
Understood.
Okay, and this is 19,000 from Mr. Allman's technical credit. She had made me open an account there for her.
Yes,
Total of $19,000.
The
Altogether,
19,000
30,500 and
is
not 26.
you will pay that.
She says 25, and if you add up, it's exactly 30,500.
All right, anything else?
And that is the money that I don't know what it is. It's on the air. No, it's in her bank account, Your Honor. It was delivered, and here is the transfer, sir, Your Honor. This is what she gave you. This, I have the same.
The 19,000, he never paid me.
All right, I'm going to, okay, this is what I'm going to do in your case, Ms. Fidauti and Mr. Montoya, as a matter of law, assuming that everything that both of you are saying is true. There are certain things that I can't fix, I can't change. In this case, cause number 2026 CVD 000033L2, the court finds that it has jurisdiction over this eviction matter. The court finds that at present, Ms. Raquel Vidauri is the owner of the property. The court finds that it is currently possessed by Alfonso Montoya. The court finds that pursuant to the agreement that is on file with the county clerk's office, this is document number 1500987, that there is an agreement between the parties, and the parties have already litigated this matter very recently in the 341st. Based on all of this, the court finds that Mr. Montoya at this time, as of today, has the superior right of possession. The court finds that he should be paying $500 per week until $180,000 is paid. And the court finds that all amounts in the court registry should be paid to Raquel Vidauri. The court will prepare its own orders with regard to that. Any and all other requests for relief not already granted is hereby denied. These are the orders of the court. Ms. Vidauri, do you have any questions for the court? Do you have any questions, Ms. Vidauri?
No, I think that's unfair.
Understood.
Because,
Do you have any questions for the court, Mr.? It's not a question. I understand. Mr. Montoya, do you have any questions for the court?
Your Honor, I didn't understand what you said.
There is a valid agreement. You get to stay. You need to pay $500 per week to Ms. Vidauri. That's what the contract says. I can't change
per
anything
week or
else.
per month?
The
So 15
contract
I'm
says
paying 1,500 a month right now.
you shouldn't be doing that. You should be paying $500 per week. That's what the order is going to say. I wish you both very well.
Your Honor, this I will pay to the court or to,
Pay to her,
but I
but-
have a.
but all of the money in the court is going to go to Ms. Vidauri.
So I give it to you. To the court and you hand it to her. I cannot go near her because she has a bond.
The
bond against-
all of the money that is with the court is going to be paid to Ms. Vidauri.
and it's gonna go-
Under the terms of this contract, you need to pay $500 per week to
Yes,
her
I will.
until $180,000 is paid.
I will.
Those are the orders of the court. I wish you both well. Have a good day.